Live on Twitter. I think we are. All right, Chuck Schumer, take it away. Tell us about the No Kings Act.
1 month ago, the MAGA Supreme Court effectively placed a crown over Donald Trump's head. They ruled that the President of the United States is in essence above the law. The President is immune in sweeping ways from accountability for, quote, official acts. 1 month ago, I said I'd work with my colleagues on legislation to reverse the damage of the court's bewildering ruling.
It's bewildering. No
on
idea.
Immunity.
Where
Today,
did this
I'm
come from?
pleased to announce Senate Democrats are taking the next step. Today, along with 33 of my Democratic colleagues, I'm introducing the No Kings Act.
All right, folks, I guarantee you the ones that are not signing on to the No Kings Act are the ones that are up for re-election this time. This is such idiocy. Oh, anyway. All right, folks, let me tell you that we're going to cover today the No Kings Act, explain to you that this is absolute garbage and what's going on here, and also give you a little primer on what presidential immunity means, okay? So let me tell you about the concept of immunity. It goes back to British common law. You couldn't sue the king, so it's called sovereign immunity, right? And when we came over here, obviously we don't have that concept of kings anymore. It's absurd. For example, can kings be unelected? Could kings be impeached, right? This is just nonsense, and he knows it. He knows it. He's not acting. But we have limited sovereign immunity. You're trying to go sue your local municipality for something, and you're going to find out real quickly that they have what's called sovereign immunity. So you can't sue them, right? Unless they've waived it for some ways, which most of the time they don't. So this is all just politics, and you can tell by the ridiculous language. If they had a point, they wouldn't be talking about kings and dictators and nonsense like that. Where does this all come from? Well, it comes from the Biden administration. Here is the Biden administration when they argued for the Supreme Court. I want you to listen to this argument. This is Biden's lawyer arguing to the Supreme Court. Take a listen.
Mr. Chief Justice, and may it please the court. This court has never recognized absolute criminal immunity for any public official.
Okay, now that's just an outright lie. And any lawyer, you don't have to be a 30-year lawyer like me to know that that's just a lie. I wrote an article about this a while back. If you're listening to us on Rumble and or Facebook or YouTube, I'll drop a link to this article, and you can subscribe to my Substack page, read the article, do whatever you want to do. And while you're doing that, by the way, subscribe to this so you get notice of other podcasts. But if you scroll down in this article, you'll get basically the main paragraph here about where immunity came. But I want to point out something real quick before I do that. Remember the Covington case, the kids that supposedly attacked the Native American? It was all nonsense. Listen to this right here from this article. On Tuesday, November 6th, the Courier-Journal reported that U.S. District Judge William Bartelsman ruled that Warren's speech was protected by sovereign immunity. I thought Biden's guy just said there's no such thing. It's never happened. Let's go back to the article. It also goes back, and they know this, to Nixon versus Fitzgerald. This is from the 70s. Now, what is important about Nixon versus Fitzgerald? Well, all the lawyers in your life will tell you that was the original case where they came up with presidential immunity. The only problem, it was civil, not criminal, civil case. Basically, Nixon fired this guy, and the guy was upset about being fired, so he sued Nixon personally, not the government. You can sue the government, right? But you can't sue Nixon for doing his governmental act. And the court said basically, no, that he has immunity for official acts. It's the same thing here, except now we've gotten to criminality. Another point to let you know how full of it they are, take a look at the D.C. Circuit, which got overruled, as did Chutkan, by the Supreme Court recently. Listen to this hypothetical. Absurd.
President ordered SEAL Team 6 to assassinate a political rival.
Who in the world is talking about assassinating anybody? They're talking about suing Trump for overvaluing assets. They're talking about suing Trump for delaying a proceeding. Nobody's talking about murdering anybody here, right? What in the world? Plus, think about it. At the end of the day, right, the president has to have some immunity. If not, there's nothing called separation of power, co-equal branches, right? If Congress can just pass laws and then prosecute the president, then how is the will of the people ever going to get out? Same thing applies to the Supreme Court. That's really what's going on here, folks. But a couple things, and we're going to get out of here, but got about 2 minutes to go. One thing at the Supreme Court, this was Biden's lawyer, again, the same guy you heard opening with a lie. He got caught in a really tough hypothetical by Justice Gorsuch. Take a listen.
And it in fact delays the proceedings in Congress. Now, under 1512C2, that might be corruptly impeding an official proceeding. Is that core and therefore immunized, or whatever word euphemism you want to use for that? Or is that not core?
So here's what he's saying. The Biden administration took the following position before the court. They said, yes, you have immunity for core functions, which I'm going to let him explain in a minute, but not for non-core. And obviously what they're prosecuting Trump for is non-core. Okay. And Gorsuch gets to, okay, well, if that's your, how does this work, right? What's core, what's non-core?
And therefore prosecutable.
Well,
without a clear statement that applies to the president.
It's not core. The core kinds of activities that the court has acknowledged are the things that I would run through the Youngstown analysis. And it's a pretty small set, but things like the pardon power, the power to recognize foreign nations.
Okay, pardon power, recognize foreign nations, appointment power. You can't prosecute that. So basically that would limit the presidencies to a bunch of very few things, right? That's what they're doing. So let's back out of this. The Supreme Court got it right. Of course, the president has immunity. I would have said that you can prosecute only if you've impeached. They went a little further and said, no, as for official acts, you can't do anything. And then they laid out some things that if it's an official act, you can overcome it in certain ways. So the SEAL Team 6 thing, you can overcome it because it could be an official act, right? But if it's an unofficial act, for example, killing your political rival would clearly be that, then you can overcome it in certain ways. But let's back away and tell you what's really going on with this. The reason this has never come up in our history, 200 years plus, right, is very simple. We used to understand the idea of separation of powers. And if separation of powers is to work, then the branches must be co-equal. If the branches are co-equal, then Congress can't pass laws, right, to criminalize the behavior of the president, to criminalize the behavior of the Supreme Court. Sound familiar? Of course it does, because that's what they're trying to do. They control the legislature right now, basically, and so they're trying to be able to criminalize everything else so that they would control essentially the entire government. That's not a constitutional republic. That's a democracy, which we're not. Okay, presidential immunity, got it right. Ignore the No Kings Act. It's trash. Anyway, if you like this, please subscribe, share it. Sharing is caring, and subscribe so you get to see us, and we hope to see you on the next one.